right. So what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody. Head up when you speak to people, okay?
Yes, ma'am, but really, I don't want to be on camera.
She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. Do you not want her back on your bond? Because if you don't want her back on your bond, you can be taken
It's
into
their
custody.
mistake, ma'am. I understand y'all doing your
Alright,
favor.
so-
It's their mistake.
He can go.
All right, I can go there.
Yes, ma'am. I just didn't understand what I was signing and.
Excuse me.
Oh, I'm sorry. I'm sorry.
All right, and let me stop you right there. So you were doing marijuana at Taco Cabana,
Yes, ma'am.
and that is why the food has fallen off. I don't consider it throwing you away. You can still do good things when you come out of prison.
Sometimes you tell the client, this is a hyphen situation. They go, what? Shut up.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. Court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We're asking the court follow the negotiated plea bargain agreement, Your Honor.
All right. So what is wrong with you? This is a person, for whatever reason, decided to pick you up from custody when maybe she should just let you stay in there, for whatever, and let you just stay there. She takes it upon herself, and I'm sure she paid your bond, and she picks you up and brings you back home, and then you beat her up. What's your issue? Yeah, I mean, you do. Because somebody do you love her, or do you claim to love her?
No.
No, you don't, because that's not the way you treat people you love. She took it, probably money from her children, to pay to bond you out, and then. All right, let me tell you what's in the police report, and you tell me what's incorrect about this. I asked victim what happened. Victim stated the following events occurred. Since Wednesday, she went to pick you up from the jail. She stated they were good, no problems. Later that day is when the defendant began to strike and choke the victim. So this is where we are.
Or I don't know if, I think he just got a little bit tangled up. I don't know if he bonded out or if he was just released at that point, and then she picked him up instead of the bond. I think that's where he was a little confused.
I was just confused because I was released from ISF, not from the county jail.
Oh, okay, so there was no bond posted. Okay, that's what I think. He was
So
confused.
here's my question. Is the reason for this offer because the complainant does not want to participate and has filed an affidavit of non-prosecution? All right. So she's filed an affidavit of non-prosecution, even though I'm looking at the photos. She has a black eye, she has bruises on her arms, and she took time out of her busy schedule to come pick you up from wherever you're incarcerated. So for some reason, she's attached herself to you, but I'm going to try to break that cycle today. So I'm going to sentence you to 3 years in prison. There'll be credit for any time served. There's a $1,500 fine. Time and money is not running concurrently. There's an affirmative finding of family violence. There's to be no contact with Ana Maria Hermio, AKA Ana Maria Gonzalez, and you're not allowed to reside in any residence with minors. Do you understand? Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed this plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. We can go off the record. Here's the thing. Don't get involved in any other relationship. Don't contact her. If you love her, the best thing you can do for her is not contact her, because you're not any good for her. And until you figure out why you feel the need to put your hands on people in anger, you should not be in anybody's relationship. Here's my advice to you. Get an orchid. I always tell people that, and this is why I tell people to get an orchid. An orchid takes a lot of patience. When you get it from the store, it's beautiful. They all have them all with the flowers bloomed on it. They will give you directions. Those directions don't work. I learned you're not supposed to put ice cubes in them. But If you can let the blooms fall off of that orchid and keep that same orchid and get it to rebloom, you may be ready for a relationship, because with orchids, you have to learn patience. You understand? All right, good luck to you.
Thank you.
You're welcome.
Is that a
After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you applied for deferred adjudication. Does he have criminal history?
Just a few misdemeanor, Judge. There's
Alright.
a pending MTR in County Court 14 that we still have to resolve, but it's I believe a criminal mischief.
All right, so does he have, are those the only things that he has?
I don't know the other misdemeanors. There may be 1 or 2 other misdemeanors.
All right, so this is what I'll do. Norma, can we reset this for maybe July 31st? And state, on this case, I'll need his criminal history. And then if he wants to have no harmful or injurious contact with the mother of the children and no unsupervised contact, the mother will need to appear. She can either appear by Zoom or in person.
Okay, do you mind doing it the first week of August? I'm out of town the end of the month.
Okay, what date are you asking for?
We can do that first week and I come back, Judge.
All right, you want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand, state your name for the record.
Tyler Stephen Small.
Why are you not reporting?
Honestly, I was at Taco Cabana and I had been smoking marijuana with my manager and I knew that I would fail the drug test.
All right,
And I thought that when I went in, I would be drug tested. And
so your answer, how old are you?
I'm 35 years old.
So you know you're not supposed to smoke marijuana. You did it anyway,
Yes, ma'am.
and you're doing it, I guess, while you're at work?
I was at Taco Cabana. When I got the MTR, I went to jail. I talked to my wife and we decided I went to do another job. We went to one that was 2 minutes away.
No,
from
no,
the
no, no,
home.
no.
Oh.
Here's the thing, you're speed talking. So you were doing marijuana at Taco Cabana,
Yes, ma'am.
and that is why the food has fallen off. So what was your job at Taco Cabana?
I was a cook.
Do you think anybody wants the cook to be smoking marijuana over their food? So you and the manager at Taco Cabana are doing marijuana,
Yes, ma'am.
and you decide you're not going to report because you're going to be positive.
Yes, ma'am.
See, you just compound your problem. So was he positive today?
Yes, Judge, it was positive for marijuana.
All right, so when did you use marijuana with the people at Taco Cabana? I'm assuming it's in February.
No, I used it up until the point of my MTR. I have not smoked since, but I was smoking every night with my manager.
All right. All right. What is his TAP evaluation? Did he have a TAP evaluation?
No, yet, not yet, Judge.
All right.
We are asking for the TAP to be complete and to follow all recommendations.
All right. Deputy, he's going into custody today. All right, this is what the court is going to do. Court will deny the motion, alter and amend conditions to include a TAP evaluation in custody, follow all recommendations of TAP. And if TAP recommends an outpatient treatment, then that's going to be 90 sober meetings in 90 days. And there's going to be a UA hotline for him until further notice. And while he's in custody too, we can do a referral to felony drug court. And to the clerk, he's going to be in custody for his TAP evaluation and for felony drug court referral.
Judge, if I may, he's no longer at the Taco Cabana job. He left. He has another job at Chester's Hamburger. He's not using marijuana anymore. They have 4 children they're supporting, and he is in a technical school that he's trying to better himself. He was able to get out of jail, post bond, and try to make better. Would the court consider allowing him to remain out to get these conditions done? You could even have him report, or we can have him report daily if you want to have a drug test. We'll show that his levels are going down. But he's taking the first step on his own to try to make better progress. We're just gonna knock him back
Okay.
a few more steps.
All right, we can go off the record. Here's the thing. Everybody who comes to this court on probation, what do I tell them? If you have an issue, pick up the phone, let probation know, because to be successful on probation, communication is key. I tell everybody that. I say, if you feel as they're not addressing that issue, you can come in and talk to the court. You didn't do any of those. What you decided to do, and you're an adult, it's not like although I know 18-year-olds, 19-year-olds are considered adult. It's not like you're an 18-year-old or 19-year-old or 21-year-old. You're old enough, you know better. And what you've been doing is been avoiding consequences. And these are consequences for our actions. Now, if you would like, I could send you to prison. So these are consequences for our actions. And what you've shown me is I can't trust you to even report for probation. That is why you're doing the TAP evaluation in custody. That is why you're doing the felony drug court referral in custody. What I can tell you, if felony drug court accepts you, today is Thursday, they'll probably see you by next week. You understand? There are always consequences for actions. And I think you're old enough to, when you make choices, you need to sit down and say, I'm making choice A. What are the consequences for that? You understand? And I don't write the rules for probation necessarily. This whole thing where you can't drink alcohol while you're on probation, even though alcohol is legal, that's not from me. That's from the legislature. This whole thing where you can't smoke marijuana, that's not from me. That's from the legislature. And I know people think, it's just marijuana. But look at you. You standing before me using marijuana every night at the Taco Cabana instead of making people's food properly, which is why I probably had some hair in my food. But you're doing that. And guess what? Going home smelling like marijuana with your children. And now you before me telling me you have children. Those are consequences you should have been thinking about. And you're on deferred adjudication for injury to a child. Do you understand? All right, good luck to you. Court is calling 2024 CR 7889A, State of Texas versus Jonathan Lopez. Could I have parties announced for the record for the state?
Daniel Escobar with the state of Texas.
Defense?
Linda Corley for defense.
Are you Jonathan Lopez?
Yes, Your Honor.
Did you review a document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jonathan Lopez who was placed on deferred adjudication in 2014 CR 7889A for the offense of robbery on February 2nd, 2015 for a term of 10 years? Is that you?
Yes, Your Honor.
All right, state.
Violated condition number 5 in Bexar County, Texas. The defendant, Jonathan Ovidio Lopez, who's entered there, failed to report to the supervision officer as directed for the months of January through December 2022 in violation of condition number 5.
How do you plead to that? True or not true?
True, Your Honor.
Your Honor, state waives all the violations.
Any objection?
No objections, Your Honor.
Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty and sentence you up to 10 years in prison and up to 10,000, I'm sorry, up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, Your Honor.
Court will find violation of condition number 5. Is there a proposed agreement?
Your Honor, it's both sides want to go open.
All right, state, what are you requesting?
Your Honor, state requesting revocation 8 years TBC.
All right, defense, what are you requesting?
Judge, we have a witness here as well, if you feel that you need her.
Oh, let's
we're
call the
request-
witness.
Okay. I call Alondra Mata.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you're going to need to keep your voice up so the court reporter can hear.
Yes, Your Honor.
State your name for the record.
Alondra Mata.
All right, off the record for a moment. To the interpreter, I'm going to take you up as soon as this witness is done.
Yes, Your Honor. Thank you so much.
All right, we're back on the record. Defense?
Thank you, Judge. Can you spell your first name for the court reporter, please?
Alondra.
And how do you know Mr. Lopez?
He's my boyfriend,
And how long have you been together?
a year and a half
Okay. And in that year and a half, where has he lived?
with me.
And during that time, was he working?
Yes, he's been working and
All right. And did he go to work every day?
yes,
All right. Has he been helping with bills and all your living expenses as well?
yes, he makes my car payment, pays half of the rent and buys the food.
And during that time, were you aware that he was supposed to be reporting to probation?
No, I wasn't aware in the beginning.
All right. And so now you're aware that he had that requirement. You understand that we're here today because the state has filed a motion to revoke his deferred.
Yes,
All right. And you understand that means that at this point, he's not convicted felon. So we're here today to ask the judge if she would consider allowing him to stay on deferred. So can you tell the judge a little bit about your experiences with him, with the responsibility and how he's been doing since he's been with you?
yes. Jonathan has been with me for a year and a half. When I met him, he was already working. We moved in together and he's been helping me pay the bills. From what I've been with him this time, he's been doing good. He hasn't done anything that shows, that he's going back to what he used to be. The person that I met is not what I know today. That was something in his past, so.
If the judge were to allow him to have another opportunity not to go to prison, why do you think that he would follow the rules at this point?
I think he's in a better place now, and I've never been in trouble, so I don't allow anything bad to, for him to do. So therefore, I know for sure that if he's with me, he's not gonna be doing anything wrong.
And you understand that he had used marijuana, and we waived those violations, but how do you feel about that?
He's not smoking and he's not going to.
Okay. If he was, would you report him?
Yes, he knows that.
Would you be there to help him to keep track of all the things that he needs to do?
Yes, I've been helping him with that as well. He's been checking in and on his own, doing what he has to do. So he's been doing pretty good.
I'll pass the witness.
I just have a few questions. It looks like it was a shock whenever you found out he was on probation then.
Not as a shock, but when I found out, I did tell him, like, you have to do the right thing now. And this is what he's been doing since he's been with me. So as far as when he got arrested, he's been following all the rules, and I hope, that's what he's gonna continue to do if he's with me.
So it wasn't a shock when you found out that he had been placed on probation for robbery previously.
I didn't know that until now.
So he never once informed you of that.
No, not until I found out.
So you found that out when he was arrested on this charge?
Yes.
And based on what you knew of him, was it a surprise that he would have had a case like that?
It is because he's a good man. He really is. So when I found out what it was, I didn't believe it, but he's with me and he's been doing good. So I think that's the person that he's trying to be from now on.
No more questions, Your Honor.
I have a few questions. When did you meet him?
January of 2023.
Where did you meet him?
I met him on social media.
All right. And when you met him, when did he tell you he was on probation? Did he ever tell you?
No, he didn't tell me that he was on probation. He was working, so we just, continue like.
Well, no, how did you find out he was on probation?
Not too long ago.
When he got arrested?
Yes,
All right. And then that's when he told you he was on probation?
yes,
All right. Do you have any children?
yes.
What are their ages?
17 and 21.
All right. And then you said that he pays the bills?
Yes,
All right, do you pay any of the bills?
yes, I do. I have a job.
All right. And this marijuana use, did you know he was using marijuana?
No. In the beginning, I knew, but he stopped.
All right, thank you so much.
Thank you.
Yes.
Judge, I would like to call Mr. Lopez.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Jonathan Ovidio Lopez.
All right, defense?
Thank you, Judge. Jonathan, you know this, we're here in front of the judge, and this is your third MTR, correct?
Yes, ma'am.
All right, so you've had problems while you've been on probation when you started, is that correct?
Yes, ma'am.
Can you talk to us about what was the underlying cause of those?
I was at the time, I was in a very dark place and I had lost my jobs and went through a major breakup with the mother of my children, and I just felt like everything was, everything was just on top of me, and I was in a dark place, and I was using marijuana as a dumb decision instead of reaching out for help and getting help from the state and myself. I put myself in a bigger holes than I was already in. And
you went to outpatient treatment, right? And you completed that successfully once, and you went a second time, and you did not complete that second time.
Yes, ma'am.
So what happened there?
I just was, I was out of work and stuff, and I was embarrassed of like asking for help, and I just didn't. My phone had broke, and I didn't continue with the Zoom.
So at some point, you started climbing out of your depression. What was the catalyst for that? What changed in your life?
I started going back to church, and seeing my kids was it gave me hope again to do everything that I needed to do and get back on track.
And on your prior MTRs, you had turned yourself in, and on this MTR, you knew you had a warrant. At some point, you went to turn yourself in. Is that correct?
Yes, ma'am.
All right. And so you went to the sheriff's office
Yes, ma'am.
and you identified yourself, and they told you to wait.
Yes, ma'am.
So you waited there for some time,
Yes, ma'am.
and then you made a decision to leave. You got scared. Why did you leave?
I was there for about an hour. Everybody called me, and I made a stupid decision just to leave instead of waiting for them to come get me. And I made a dumb decision, and I left, and here I am back in court.
So you began working once you started seeing your kids and you started pulling yourself out of the depression. You started working again. Where did you work?
With my uncle doing roofing.
Okay. After you were arrested, he didn't want you to come back to work for him. Can you explain why that was?
He was dealing with his own problems with probation and other stuff, and he just didn't want me to affect with whatever he had going on.
And did that have something to do with your ankle monitor?
A little bit, because where he goes, we go to like certain places, and he didn't want for me to be on monitor and go to like certain places that he needs to go, like his bases and different stuff, for them to decline his contracts and stuff.
Okay. And so at some point you met Alondra,
Yes, ma'am.
and how did that change your life?
She's a good person, and we started going to church, and I feel like she's pushing me to be a better person than I was, and she motivates me to be a better person.
You know, this is your third MTR, correct?
Yes, ma'am.
Why should the judge give you another chance after she's already given you two chances? What's different now that you can assure her that if she does give you this chance, that you're not going to give her another reason to put you in prison, that you can be an upstanding citizen and continue working and being a good force in the community.
Before all this that I'm going through is, I was young. The case is over about 10 years old, and after that, I haven't picked up any new cases, and I haven't gotten like major trouble since then. And I know I made stupid decisions along the way when not reporting, doing the UAs and stuff. But I was using marijuana as, how I say, like coping mechanism, when instead of I should have asked for help and asked my probation officer for different ways. And I made dumb choices instead of
But you had
doing the
help.
right thing and going to,
So you had help, but you blew that, right? You had the outpatient and you messed that up. What was your mental condition at that point?
I was just in the dark place. I wasn't thinking correctly.
And you had picked up a couple of possession of marijuana, shoplifting, and a driving while license invalid at some point during your probation, correct?
Yes, but that was over 7 years ago.
Okay. And so are you using marijuana now?
No, no, ma'am.
If you were to test, would you test clean?
Yes,
You
ma'am.
understand the judge could send you for testing if she wants.
Yes, ma'am.
Pass the witness.
State?
Just a few questions, sir. So you never told the laundry about the fact that you were on probation, did you?
I told her that I was in trouble, but she really didn't believe me until I recently got incarcerated.
Did you ever explain exactly what you meant by being in trouble?
I kind of like explained it to her, but she just didn't believe because she didn't see that person. And I explained to her, and I would explain to her, and I told her that I need to make enough money to get a lawyer because I'm in, major trouble. And she didn't believe it. And when all this happened, when I recently got incarcerated, and I guess she saw for herself, when I came home, she still don't believe that. But I told her it was something that it's over 10 years ago. I believe everybody has a second chance or deserves a second chance.
You would agree that you've already had 2 prior MTRs, right?
Yes, sir.
So would that have been your first and second chance?
Yes, sir.
No more questions, please say.
All right, anything else?
Nothing, Judge.
Any other witnesses?
No, Your Honor.
All right, the court is going to find you guilty. Grant the motion. You all want to speak to time?
Your Honor, state's still gonna write the date, please.
Defense.
Judge, may I address the court about the issue? I understand that we can throw him in prison.
All right, so counsel, I will hear your issue, but here's the thing. I know that I'm not the person who placed him on probation because he was placed on probation in 2015. But since that time, you've had motions to revoke with me. And I know that I tell everybody, if there is an issue, let your probation officer know. If you feel like they're not addressing it, you can always come back to court. He's just disappeared. And I'm sure everybody has read the court summary. He's disappeared. And I internalized everything that was said to me. And you know what usually happens, Mr. Lopez? People will call witnesses to come in. And you know what? It's always the witness acting as though they're on probation. I'm going to make sure this person doesn't use marijuana. I'm going to make sure this person reports for probation. They're not on probation. You are. All you had to do was report. And guess what? If you're testing positive for marijuana, it is rare that I revoke somebody for testing positive for marijuana. I let them know. I know marijuana is legal in other states. If you want to make it legal in Texas, contact your legislature. But while you're on probation here, you're not allowed to use marijuana. And I know the last time we were here, on your motion to revoke, where you were continued, I said those exact things to you. And now when everything comes to a head where somebody has a motion to revoke and they wouldn't report it, all of a sudden, everybody has their life together. I'm married. I'm engaged. I'm with a lady. I never told her I was on probation because you know what ends up happening? Guys, when they end up with women, sometimes women will fall in love with you. Maybe they're falling in love with your publicist. Maybe you haven't presented your full self. But I know usually when women fall in love with the guy and they don't know all of this history, then they get hit with the history. And guess what? They still in love with that guy, just like the witness who came to testify for you. She's still in love with you. She still wants to do everything to keep you out and about. But you're not a good candidate for probation. I don't consider it throwing you away. You can still do good things when you come out of prison. I'm not going to sentence you to 8 years in prison because you have done some things on probation, but I'm not continuing you on probation. So you're going to be found guilty. I'm going to revoke you. I'm going to give you credit for any time served. I'm going to suggest the therapeutic community. There's going to be no contact with Maria, Ahmed, and James Tristan. I'm going to order the removal of GPS because you're going to be in custody. They've asked for 8. I'm not sentencing him to 8 years. I'm not going to sentence him to the minimum. So what are you asking for?
Judge, I would ask for 3 to 4. He did make an effort. He has turned himself in the past, so he's not somebody who keeps absconding and not putting himself forward. Judge, he has followed all the rules. He could have run. He didn't run. When I went and talked with him this morning, we talked seriously about the fact that this may very well happen. And he didn't run, Judge. He didn't leave. I've had clients who just run out the door. He didn't do that. He still stood here to face. So although he made some bad decisions and he didn't handle things well, I think he has improved his life. And I understand that you may not believe that, but I've talked a lot with Alondra.
Oh, no, I believe he's improved his life.
Very, very stable. And so I think he hasn't been living under a bridge or using hard drugs or living off of other people, and he's been working. So I would ask, given that you give him 3 to 4 years, Judge.
All right, I'll sentence you to 4 years in the prison. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it?
Yes, Your Honor.
Because this is a plea bargain agreement, you have a limited right to appeal. And that right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. I hope you understand the reason why you're being sent to prison is because your actions. It's not because of the person you were with. At some point in time, we cannot just go off and live our lives and pretend like we're not on probation. And when you tell me I haven't picked up any new charges, there are a whole host of people in this courtroom who haven't picked up any new charges. When you tell me, oh, I've stopped using drugs, there's a whole host of people who are abiding by the rules and not using drugs. The fact that you have not picked up any new charges, yeah, that's something I'll consider, but it's not the be all, the end all, because you shouldn't be picking up new charges anyway. So when you're released from the prison, I realize prison time is difficult time. Anytime you're locked up is difficult time, but you need to stay on the straight and narrow. If she ends up waiting for you, then she'll end up waiting for you. Make sure you don't bring any problems to her doorstep. Don't go to prison and get institutionalized. When you come out, if you feel like you're going to use drugs or you need help finding a place that could help you with any drug issues or whatever issues you may have, if I'm still here, you can come back and I'll make sure that you get that help. You understand?
Yes, Your Honor.
All right, good luck to you. Who's here? Are you already on Sergio Chavez? All right. Who is the prosecutor on Joe Hernandez? Thank you. All right, so in this case, there was a surveillance video. Complainants.
Yes, ma'am. So it looks like from the records, we've tried to get that and the owner of the location didn't want to hand that over to us. So I think Ms. Kramer is gonna.
Well, did anybody subpoena the surveillance video?
That's what I asked. I mean, I don't really want to be the one to subpoena it because it's kind of like.
So I mean, the
shooting
video
myself in the
needs
foot.
to be subpoenaed. Which business is this?
It's a hotel, I believe, Judge.
Oh, yeah. So, I mean, the surveillance video,
I mean,
I'm
it-
assuming, does this allege to show what happened?
it would appear that it would. I don't, and I asked Hank, because I don't know what it's going to show. If he needs it to prove the case or not, I don't know, but at this point on a second setting, that's where we're at.
All right, so,
And
I
obviously
know
would
it's
prefer
gonna
the
need to be
state to
preserved. Yeah, I understand. I know it's gonna need to be preserved and subpoenaed, because if this shows the alleged offense, then it shows it. If it doesn't show it, then it doesn't show it.
And I don't, obviously, we won't know until.
We
we see it.
requested it and he didn't want to give it to us. So I was suggesting to Ms. Kramer that if she subpoenas it, that we might have more success that way.
But then it may not really be very good for me.
All right, so, state, you're probably gonna have to subpoena the video. All right, and if the video is going to be subpoenaed, that needs to be done before the end of the week.
Okay, Your Honor.
All right, and then speaking to the complainants, has that been done?
Yes, Your Honor.
Okay.
By our victim advocate, not by.
Okay, sure. All right. So I'm gonna reset this for discovery one more time, and that's just for the video. And Ms. Ferguson, can you give me a 1 month setting for discovery? And are you Joe Hernandez?
Yes, ma'am.
Right. The defense has filed a motion to preserve evidence. And I think it would be best if we take these one by one.
Okay.
So the first thing is an Eagle video. Does an Eagle video exist?
My understanding is no, Judge.
All right, state, I'm sorry, defense, do you know whether or not an Eagle video exists? The
I
state is
can-
saying it does not exist.
It's referenced within the file, which is why I was, and noticed that I didn't have anything like that in my e-discovery. So I did ask Jason to check on that. I'm not being told why if it got destroyed or if it never existed, it shouldn't have been mentioned, but I'm told that it doesn't exist.
All right, state, with regards to the Eagle video, are you able to get some sort of documentation from whoever is over that, at least send a notice to you stating that the Eagle video does not exist?
Try, Judge. I mean, there should be someone who should be able to. My understanding is that if it's Jason that reached out and got the response, then there should be an email about that, but I can confirm with Jason, but it's at least my understanding that the Eagle video doesn't exist.
All right, so I'll put in here that the state is to provide the defense with documentation that the Eagle video does not exist. And defense, is you still think that somebody hasn't looked somewhere and you
I'll
want to
let you know.
subpoena the person with Eagle, then you can subpoena them and we'll have a hearing on that.
Okay, thank you, Judge.
All right, then the next thing is a surveillance video from a hotel.
Yes, Judge. At the first setting, by the time we got really to the first setting on this case, it appeared that I had a lot of discovery, but I didn't have any kind of a surveillance video. Being a hotel, I thought there might be one. So at that setting, I asked Jason to check, and apparently he did check. Apparently he called the hotel owner, and the hotel owner told him he had the video, but he wasn't going to give it to him. I never did get any email letting me know of that conversation, but Jason didn't subpoena the video after that. That was at this last setting when I discovered that. Then you ordered the state, and this may have been done by now, to subpoena the video. But, out of an abundance of caution, I just wanted to make sure that I did everything I could to make sure that we got that. It does exist, because the hotel owner told Jason he wasn't going to give it to him.
All right, state, do you have an update on the hotel video?
I just, Judge, it made me worried with the hotel owner being reticent to give it to the state upon request, that he may destroy it.
Okay, just one moment. Let me write this down. All right, so does it shows that it's actually been subpoenaed or has it not been subpoenaed?
So it's just a note from Hank saying that it's been generated. So
All right, so a subpoena needs to be generated for that video. And that needs to be generated today.
Judge, my understanding from looking at the notes, it's not that he's not willing to give it to us. I think at least as far as from the notes, I don't know what Jason, there's no note regarding Jason's conversation if that happened. But just that SAPD tried to reach out to the hotel owner and he never responded to any calls. So that's at least the only notes I see.
All right, so this is what's going to end up happening. The hotel owner, whoever it is, it's probably best for them to be subpoenaed to come to court. and bring the video, do a subpoena duces tecum. And that way we will know if the video is still in existence. And state, I understand what your issue may be with the motion that I'm ordering you to order somebody to preserve something that you don't have. So what we're going to do is, with regard to that video owner, we're going to recall this for February 22nd. That'll be on a Thursday. Are you available?
I'm sure I am.
All right. So state, you need to subpoena that hotel owner and do a subpoena duces tecum to have them bring that video in. Norma, we're going to have a hearing with regards to the video, the hotel video on this case on February 22nd.
I think that pretty much should cover it, right?
Well, you have body cams, dash cams, state. The police, I'm sure, know that they're not to destroy or purge, let me purge any body cams. And I don't think the body cam is purged while the cases are open. Am I correct?
Yeah.
And then she wants preserved forensic samples, photographs, negatives of photographs, videotapes, fingerprint samples, or other material of a forensic nature, including evidence collected at the crime scene and any actual physical evidence. Any objections to that? And number two, any body cams, dash cams, surveillance videos, and surveillance videos, we've addressed that.
Yeah.
So is there any objection to the court removing that from number
That's
two?
fine, Judge.
So then it's, number two is then any body cams, dash cams, photographs, audio tapes, and or videotapes made, and any maps, sketches, and or diagrams made in connection with the state of Texas investigation of the alleged crime. Okay, you're gonna have to keep your voice up for the court reporter.
Sorry, Judge, under Michael Morton Brady, I think we just have to preserve any of that and provide it to the defense if it's in our possession or if it exists.
Number three, any and all reports, laboratory analysis requests, notes of lab personnel and or technicians, slides, samples, and any other documentation of whatever kind associated with or relating to the accused or the offense with which he is charged. Number four, any notes or reports, whether handwritten, tape recorded, and or transcribed of law enforcement or other agents of the state of Texas, which relate to any investigations of the accused or anyone else suspected of having committed the same offense as that with which the accused is charged. Number five, any notes, audio tapes, videotapes, or writings known to the state of Texas purporting to be the statement of any person having knowledge about the case. All right, so
Well, usually when I file these, I'm talking about different notes made by police officers and the different, that might not have made it into a supplemental police report, and those should still be preserved. Could potentially be exculpatory,
all right, so do you want to change the statement to any person having knowledge about this case with the exception of work product?
That's fine. Yeah. I know I'm not going to get their work product.
Okay. Number six, any and all videotapes, audio tapes, and or handwritten statements by the accused or which purport to be a verbatim statement of the accused. This includes statements written by someone other than the accused, but which were acknowledged orally or in writing by the accused. All right, number seven, any and all uniform offense reports or supplements thereto. Number eight, any reports, statements, recordings, or other documentation of, by, or about fellow inmates with whom the state or its agents might have discussed any matters pertaining to the accused. Oh, I think that's similar to if you all have, somebody talks to him at the jail and they're coming, any police logs, records, recordings, and or notes of calls and reports to the state of Texas, its agents or employees, or any other law enforcement agency regarding the accused, his arrest, or incidents related to the indictment or charge pending against the accused. All right. Then what the court has done internally, what's agreed to is one, so the court will grant it. Number two is agreed to, and the court will grant it. Number three is agreed to, and the court will grant it. Also, the state is to provide documentation of the existence or non-existence of an Eagle video. And with regards to the hotel owner and the video, there should be a hearing of that on February 22nd, 2022 at 9 a.m. The state will subpoena the the hotel owner and do a subpoena duces tecum and have the video here. Of course, if you all have the video before February 22nd, then there will be no need for the hearing on February 22nd.
Thank you, Judge.
All right, is there anything else, counsel?
There is not, Judge. Thank you.
You're welcome. Anything else from the state? All right, so.
Well, Judge, I mean, I can just represent that at the first setting, Jason did tell me that he talked to or somebody, but it was represented that the hotel owner was requested of the video and he said, no, he wouldn't turn it over.
All right, well, we're gonna get him to turn that over. So state, I'm sure if you let him know, he will be in court. Then we'll probably have the video. All right, is there anything else?
There is not, Judge. Maybe be excused.
All right, is there a chance that your client is going to bond out?
I'm not sure that that's.
Oh, that's your attorney will file something and then we'll have a hearing in front of Judge Nahara. Ms. Ferguson, in case he's released, can you give him a reset form for February 22nd?
February 22nd.
Yes. And it will just be a discovery motion, a discovery hearing. 10221 State of Texas versus Joe Hernandez. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
Defense?
Suzanne Kramer for Mr. Hernandez.
All right, and are you Mr. Hernandez?
Yes, ma'am.
All right, so we're here for a hearing. There is an issue of discovery with the hotel video. And we do have the person who's responsible for the hotel video on Zoom. Any objections to Ms. Kramer and Mr. Patel appearing by Zoom? State?
No objection, Your Honor.
All right, Mr. Hernandez, do you have any objections to your attorney and the witness appearing by Zoom?
No, ma'am.
All right, defense, my understanding you had some questions you wanted on the record addressed to Mr. Patel, is that correct?
Yes, Judge.
All right, Mr. Patel, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you need to lower your hand and make sure you speak up because the court reporter has to hear. If you'll state your name for the record.
Neil Patel.
All right, and it is Neel. All right,
Yes.
defense.
Yes, Judge. Mr. Patel, by my records, this offense that we're seeking the hotel surveillance video occurred on August 25th of 2023, if you recall.
I'm sorry, can you repeat that again?
The offense of which that we're seeking to get your surveillance video occurred on August 25th of 2023.
Yes.
Okay. Do you recall at any point in time in the days after that somebody from the San Antonio Police Department came to your location requesting the video?
They might have requested with the employees, but I don't think I was here August. No.
Would you happen to know who those employees are that
My
were there
front desk.
working? I'm sorry?
My front desk, maybe.
You need to spell that.
He said the front desk,
Oh,
maybe.
the front desk, maybe. Is there any way that you have access to who of your employees were working on that day?
No.
Or from 8/25 through, you don't keep records of when your employees are working?
Yes, we do, but for 2 months.
So if I'm
We discard the schedules after 2 months.
So if somebody wanted to know if somebody was working at your place after previously from 2 months ago, you wouldn't be able to know that?
No.
Do you pay them by a check?
Yes.
So there would be some sort of documentary evidence because of their paychecks when people were working.
Yes. So I just said I don't recall who was working that day. But yes, if I do the finding, I can find out.
So as far as you know, you were never spoken to by SAPD and your employees never told you, the hotel owner, that SAPD, San Antonio Police Department, came to your hotel wanting a piece of evidence?
I'm sorry, can you repeat that?
So as the owner of this hotel, or at least the manager, correct?
Yes.
You're the man in charge.
Yes.
You were never visited by San Antonio Police, and as far as you know, none of your employees ever came to you saying San Antonio Police wanted to see if there was a video available.
No,
Do you recall having any kind of telephone conversation with any member of the DA's office within the last 2 months referencing this video?
I'm sorry, your voice is a little low.
I've never been accused of not speaking really loud.
Or maybe
The
my laptop.
question is, did you have any conversations with the district attorney's office about this video?
No,
So you say that these videos are recorded over within 36 hours.
yes, a loop of 36 hours.
So I guess this video, if the offense date was 8/25, it would have been recorded over by 8/28 of 23.
Yes, 36 hours, so I'm like 27th or 28th.
All right, Judge. I just wanted to establish that for the record. I don't have any further questions.
All right, any questions from the state?
No questions, Your Honor.
All right, thank you for coming in, Mr. Patel. You're excused.
Yes, thank you.
There is no video.
Yeah, I just feel like I'm getting different information from the state and Mr. Patel. Of course, it may be his employees, Judge. It just seems to me if his employees had been contacted by SAPD, they would have told him that. I mean, I don't know what's on this video, so I can't really speak to whether it's, exculpatory or not. But I just don't, I'm going to have to kind of research this further to see when I want to go further on. I know at this point, there's nothing I can do because right now there is no video.
Yes, Judge.
Yes.
All right, Judge, he's on his way up. For your edification, this was a plea that we entered in front of Judge Angelini for 10 deferred.
Oh, no, I remember.
Okay, well, I'm just going to fill you in on what's going on there today.
All right, what's happening today?
So I asked the DA if he would be willing to consider the 10 deferred. He said, let me think about it. We did enter the plea fully and officially on the 4 silent. Mr. Hernandez then tells me he wants me to put in a motion to dismiss for prejudice, and I told him there is no such thing because, judges bust plea bargains all the time. That doesn't give you a right to dismiss. And so then he says, well, he wants a jury trial. And I said, well, we have entered the plea on the 4 silent, so the judge may or may not allow you to withdraw your plea. And then that's what he wants to speak to you about.
All right. All right, we can go on the record.
Yes, ma'am. I just didn't understand what I was signing and.
Excuse
She
me.
hasn't
I'm
started
sorry,
yet.
I'm sorry.
All right, and let me stop you right there. All this thing where people say they don't understand what they were signing, based upon what is the information that I've received, that first it was 10 years deferred and the judge denied it, and then it came back to a silent offer. Yeah, everybody understood. Court is calling 2023 CR 10221, State of Texas versus Joe Hernandez. Can I have parties announced for the record for the state,
Daniel Escobar for the state of Texas.
for the defense?
Suzanne Kramer.
All right, and are you Mr. Hernandez?
Yes, ma'am.
All right, a plea was entered. Let me see what date is stamped on here. On April 22nd, 2024. According to the plea bargain agreement, punishments to be assessed at 4 years in the prison. There's a $1,500 fine, and the state is silent on the defendant's application. All right, with regards to the plea bargain agreement, the court, of course, does not have the PSI because we're coming back. Can someone tell me what his criminal history is?
Judge, I don't have a file on the applicant.
Basically, I could be off on this, but my memory is some minor misdemeanors and no felony convictions.
So counsel, do you wish to have a PSI done, or do you wish the court to make its ruling?
Honestly, Judge, based on his criminal history, and of course, you don't have the benefit of the interview with him, but Mr. Delgado and Escobar and I can fill you in on part of the, I think it was part of this plea bargain too, was evaluation for Mick. There are definitely some mental health issues going on. You can tell by reading the report, but you do not have the benefit of having that in front of you. But I do feel confident, of course, it's up to him to go forward today.
All right. So I am reading the police report. And based upon the police report that I've read that are in the stipulation, there is documentation of bizarre behavior. And I don't know, based upon the police report, if that bizarre behavior was drug induced or if there's some sort of mental health issues.
Which is why I think we had dual, right, with Mick, or was it just Mick?
I'm making that, yes, that was.
I mean, based on my time, and certainly I'm not an expert in any way, but I would tend to think it might have been both, but definitely some mental health issues.
All right, Mr. Hernandez, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Joe Hernandez.
All right, so Mr. Hernandez, have you ever been diagnosed with any type of mental health issues?
No, ma'am.
All right, not even in your childhood?
No, ma'am.
Drug use?
No, ma'am.
You're telling me you never used any drugs?
No. I'm an alcoholic, yes. I drink, but that's it.
All right, so in the stipulation, they're saying that you were exhibiting bizarre behavior.
Somebody was trying to take my life that night, and I was just trying to save my life. I was asking for help. And I didn't want to die that night. Somebody came at my door trying to kill me.
And I did.
And I ended up at the hospital. I called the cops. She has the phone record that I called the cops asking for help. I ended up at the hotel. I did everything wrong, yes, but I was just trying to save my life that night. I didn't want to die that night. I didn't want somebody to take my life for no reason. That's the God's honest truth. And I'm here fighting this. I don't have mental issues.
Oh, I mean, if you want a jury trial, we'll give you a jury trial.
I'm 34 years old.
No, if you want a jury trial, you can have a jury trial. That's your question.
Or you can request the judge to give you deferred, and then that way you know that, you know what the end result is gonna be.
I have a right to face my accuser, Your Honor.
No, here's the thing. And this is what I don't think people understand. We can go off the record. Everybody thinks that they can be an attorney without a license. They want to throw around magic words like Jack and the Beanstalk. Oh, let me throw right to accuser, right to confront. Let me throw, I want a dismissal. The question is, do you want a jury trial? Yes or no? And let me explain something to you. If you say you want a jury trial, this train is going to a jury trial. This train is not at the last minute. Oh, I see witnesses walking in the door, so therefore I'm deciding to enter a plea bargain agreement. If you want a jury trial, court will give you a jury trial. You will get a quick, fast jury trial. So you want to discuss that with your attorney? You can. You all want to discuss that?
I'm good with the jury trial.
Do you want to discuss that with your client?
I think based on my conversation with him earlier this morning that he is, because of what happened the other day, it just took him off of pleading and he wants his jury trial.
All right, we're coming back on June 3rd.
Thank you, Judge.
And you will have your jury trial and your plea deadline date has expired.
Thank you, Judge.
You're welcome.
May I approach your?
The rules of the court. Your attorney will be here. Excuse me, are you all on the docket?
Yes, ma'am.
All right, what's your name? All right, Raymond Jackson. What page is he on? Do you have your case number or SID number? Do you know, are you supposed to be in the 187th? All right, just have a seat. And who are you, sir?
I'm not me.
All right, next time, no shorts in court. You understand? They're bringing, oh. Okay, sir.
I have to ask.
All right, sir, what's your name?
2024,
Could I see the file on Raymond Jackson?
Yes, ma'am.
No.
01 0935.
Oh, for Jackson? Okay.
I got his case pulled up already, so I just gotta print it.
All right, thank you. But John, it's turning into a crazy Halloween today. Now that I didn't think. All right, Mr. Jackson, we're gonna see what's going on, all right?
Okay.
Thank you for dressing appropriately for court.
You're welcome, ma'am.
Always keep your head up when you speak to people, okay?
Yes, ma'am, but really, I don't want to be on camera.
Mhm. What page is he on the docket? Ah, all right, he has a warrant. Why does he have a warrant?
Because the bail bonds made a mistake.
No. I'm asking second chance.
Oh, he had a warrant from August. We hadn't received any payments from him since March. We had to issue a warrant in August. But he did come back and make a payment. So we've been trying to restore the bond since August 28th. We've tried to restore the
Here's the thing.
bond.
Just 1 second. Let me explain something to you. You have to put on your listening ears. Do you not hear? It sounds like she's trying to get the warrant pulled so they can be back on your bond.
Now, that's why I raised my hands.
So
After she
here's the
speak-
thing, we don't need you to raise your hand right now. Right now,
She just
she's
lied on me,
trying,
man.
here's the thing. She's trying to say she wants to be back on your bond. Do you not want her back on your bond? Because if you don't want her back on your bond, you can be taken
It's
into
big
custody.
mistake, ma'am. I understand y'all doing your
Alright,
favorite. It's
so-
big mistake.
He can go.
All right, I can go there.
He doesn't want you back on his bond.
Okay, am I excused?
Yes, you're excused.
Thank you. Have a great day.
You're welcome.
Happy Halloween.
Happy Halloween.
Maybe it was a trick.
Yeah.
Oh.
See, that's what's going on.
Should have chose the treat instead of the tricks.
And you know what? It's like, even if somebody made a mistake and your freedom is at stake, the time to get upset about it is after it's corrected, because it sounded as though they wanted to get back on his bond.
Yeah.
And I'm
So
like,
sometimes you tell the client, this is a hyphen situation. They go, what? Shut up.
I'm like, okay.
Oh, go ahead, John.
All right, yes,